Good morning. Bonjour. First of all, I apologize for the technical interruption. We can always blame it on the blizzard outside. Why not? We'll be blaming everything else on the blizzard today, I suspect, including airline flights. I do want to thank those physically in attendance today. Those of you on the web, who are the vast majority, may not be aware that it requires either a long wait for a taxi or some good snowshoes to get here today. We're in the midst of an end of winter storm, which I think we can also blame on Western Canada. It seems to have come from there. Today, before we move into the presentations, I just want to remind people in terms of questions for our speakers that the people in the room will be given cards and have cards that they can write questions on and will be passed up. And for people on the web, you have the option of just clicking on the address that you'll see on your screen and sending an email that way. Pour répéter, pour les participants par web diffusion, vous pouvez adresser vos questions au conférencier à l'adresse électronique sur la page de la web diffusion. Today, we're going to move into, I guess, a more perhaps in-depth exploration of some of the questions that were raised in the last session yesterday by Mr. Justice Gouge with respect to expert evidence, and specifically some of the problems encountered by advocates when they're grappling with science in a courtroom setting. We're delighted to have as a presenter Professor Heather McLeod-Kilmurray of the Faculty of Law at the University of Ottawa. I should say that I believe she is the only speaker who now has spoken at both of these symposia, and who knows, maybe we'll tap her for next year. She seems quite protean in terms of her reach and grasp of environmental law. Last year, as I said, she was with us remotely, and today we have her here physically, which makes it even nicer. So, Heather, I'll pass it over to you.
Thank you very much, Owen, et bienvenue tout le monde chez nous à l'Université d'Ottawa. Ça nous fait grand plaisir de vous accueillir ici, et je vais présenter en anglais, mais j'accueille avec plaisir des questions en français aussi. So what I'm going to be speaking about today is, before we get into the practicalities, which we have these wonderful practitioners here to speak to us about, from the so-called ivory tower, I wanted to talk a little bit more about some of the broader or theoretical type questions that we might ask ourselves before engaging in strategy about the use of science in courts. And so that's what my presentation will be focusing on. So some of the questions in terms of this that I allude to in my paper, obviously the debate about science and law, what are the differences between the two, how can they speak to each other? The literature is vast on this subject, had a huge surge after the Daubert decision in the United States. And so some of the things that we can try to focus on in the brief time that we have today, first of all, I'd just like to address the issue of the obvious fact that not all, but many advocates and judges are not scientific experts. Some may be, but that's certainly not their purpose, and we can't rely on that certainty. So in trying to use science for advocacy purposes, what does an environmental advocate need to know about science, and what does she need to help judges to understand about science? And this context is much narrower in the context of environmental prosecutions. Most of my research in this area has been in relation to science and the law in the context of tort litigation. And so I think the contrast between the two is very informative too, so we'll just talk a little bit about that. The second point is to try to understand the different goals and standards of proof in science and law, the idea that they don't necessarily line up, and how can we best try to mix them or join them together in an effective way. And then finally, the issue of scientific uncertainty. Does it play a role in environmental prosecutions? It's quite different than its role in sort of toxic tort litigation, but just to try to explore that a little bit. So in terms of the purposes of science and law, we have this notion that this is a completely separate way of thinking, that scientists and lawyers can't understand each other's language. And are they even trying to do the same thing? So those that argue that there is a link between the two argue, of course, that the purpose of both disciplines is the search for truth. We're all trying to get at the truth. We're all trying to understand how reality works, how it ought to operate. But of course, there's significant differences, and those who say that these are two very separate streams would say things of this kind. So this is from the Daubert decision, which was so important in the United States. Scientific conclusions are subject to perpetual revision. Law, on the other hand, must resolve disputes finally and quickly. The scientific project is advanced by broad and wide-ranging consideration of a multitude of hypotheses, for those that are incorrect will eventually be shown to be so, and that in itself is an advance. Conjectures that are probably wrong are of little use, however, in the project of reaching a quick, final, and binding legal judgment, often of great consequence, about a particular set of events in the past. So this is one way of looking at the distinction between the two and this notion that they can't communicate or that they aren't particularly useful to one another. Oops. So I'm going to skip ahead to this one first. So before we focus in on environmental prosecutions, it's important to understand what is the purpose of the law, the area of law, the legal activity that we're engaged in when we appear before a court of law. This is exemplified by the differing standards that apply, but we're trying to just unpack why these are the standards and why there's such a difference. So we all know that in criminal law, the standard of proof is beyond a reasonable doubt. In tort law, the standard of proof is a balance of probability. In administrative law, the purpose is to find out whether the behavior of the executive branch is reasonable most of the time. Sometimes we have the stricter standard of correctness. So even within that field, there can be varying standards depending on the type of question involved, depending on the goal to be achieved. And then there may be other types of legislative standards that may exist in statutory provisions, and which may be even more enticing. During my presentation, we can talk a little bit about what we could imagine other standards might be that might be more appropriate to the environmental context. And so a similar thing applies in law. So this notion that science is trying to achieve the truth, that it works on a long-term time frame, that it waits for 99% certainty before it will provide an expert opinion, for example, this is also has been pointed out by several scholars, such as Eisenberg, to be a little bit oversimplified. And so we have a variety of scientific fields that prosecutors are extremely familiar with, and that you need to become familiar with this wide range of types of science. So epidemiology, toxicology, environmental engineering, medicine, oncology, these are all very, very different types of science, all of which may be relevant in a particular piece of litigation. Ornithology came up in a particular recent case that I think we're going to be hearing more about. And so what are the standards of proof in those fields, and what are their methods of arriving at their conclusions, and for what purposes? So one of the classic examples is epidemiology being the most different from law, because epidemiology looks at very, very long-term effects, can take generations to come to a clear or certain conclusion, and can wait. They have the luxury of waiting. That their danger is coming to a conclusion before they're sure. There's not a danger in waiting for 1 or 2 generations to arrive at a conclusion. And so there's a perception that that's what science is like. But in clinical medicine, for example, if you appear before a doctor and you have a pain or you have a lump of some kind, they're not going to wait for 2 generations to reach a decision, clearly. A clinical doctor is going to work on the evidence available, limited though it may be, uncertain though it may be, and come to a conclusion based on the best evidence before her at the time. That's much more like what a judge would do in a particular case. And so this notion of what kind of science is useful and how should we use it needs to be a little bit more specific. What are we trying to do in law? What is the purpose of this particular activity in law? And what field of law are we in? But then also, what is the goal? What is the methodology? What is the notion of certainty? What is the standard of proof in the field of science that we're dealing with? And of course, this could be varied. Often in environmental prosecutions, there's a wide variety of fields of law that are included, but each one is slightly different. So to be aware of that and to make judges aware of that when we're trying to achieve our standard of proof and to achieve our evidentiary burden is very important, to just stop and go back to consider that. So coming back to the specific context at hand, if we're talking about environmental regulatory prosecutions, this is a little bit different than criminal law, and it's quite different from tort law, but what is it exactly? So some of the rationale for this standard of proof being beyond a reasonable doubt in criminal law, as we all know, is that the consequences for a finding of guilt may, in strictly criminal cases and in the most serious type of criminal cases, such as murder and things of that nature, incarceration is an extremely serious, obvious infringement on individual liberty. And so in criminal cases, judges are often driven by this notion that it's much worse to wrongly convict an innocent person than it is to fail to convict a person who may in fact be guilty. So there's this presumption that's very powerful in criminal law, that we want to avoid wrongful prosecutions. And we prefer sort of any potential public risk of releasing people who may in fact be responsible. In tort law, it's completely different. So the idea in tort law is the balance of probability is between the two. And so this tends to favor the plaintiff, whereas the criminal standard of proof tends to favor the defendant. So what are we exactly trying to do in environmental regulatory prosecutions? We do know that there is a handful of criminal code offenses that can apply in environmental cases, in which possibly incarceration could be involved as well. So perhaps in that situation, this very high standard of proof of beyond a reasonable doubt similarly applies as it would in a non-environmental criminal case. But in environmental regulatory prosecutions, we have a range of options, as you've heard already from some of the other papers. And so when we get to absolute liability versus strict liability, again, we see this preferencing of one type of goal over another. And so mens rea is exactly like a criminal code offense, but the absolute liability is completely the opposite. It's this social decision that we would rather pin this problem on the alleged offender because we have a strong need to protect the public. So if you're working with extremely dangerous materials, no matter what you do, no matter how careful you are going to be liable. So that's where does the fault-based approach lie there, and what are the primary concerns involved in that case? So with strict liability offenses, which is what the majority of environmental regulatory offenses are, the idea is this is one definition, the most often cited definition from Wholesale Travel. The objective of this type of offense is to protect the public from the potentially adverse effects of otherwise lawful activity. The concept of fault is based on this idea of reasonable care and does not imply moral blameworthiness. And so the focus is on prevention of future harm through the enforcement of minimum standards of care, as we've already heard in previous presentations. But to focus in on this is very different from preventing wrongful convictions. The emphasis on even preventing risk, this is even preventing the public from potentially adverse effects. And the idea of prevention seems to be more significant in this situation. And so it's just interesting to ask ourselves, and there would be a variety of opinions on where you might fall on this, but just to ask ourselves, is this really the same thing as a criminal prosecution? Is the standard of care exactly the same? Is the standard of proof, et cetera, going to be enforced in the same way? Should it be? is there room for more creativity in this area? Another issue that comes up quite frequently in the discussion of the relationship between science and law is this idea of uncertainty, and in particular, obviously, in the context of environmental cases. Uncertainty is a huge problem. And so scientific uncertainty arises for a variety of reasons. There's different kinds of uncertainty. So there's the type of uncertainty where we've done our best, we've investigated as thoroughly as we possibly can. Even with all of the evidence that we've been able to marshal, we simply can't answer the question. We don't know. In that situation, at least we have the benefit of saying that we know that we don't know. We don't know, we know exactly what it is that we don't know. So we can at least say with some standard of clarity, this is the risk that's involved. This is the type of risk that we're afraid of, that we're concerned about. We're uncertain about this. We're uncertain to this degree. And of course, there's other types of uncertainty that we may not even know exist, the famous politician's quote of, we don't know what we don't know. And in that case, we may be operating on a presumption that we do have certainty because we're not even aware of the potential risk. So there's various types of uncertainty. There's also the reasons for this uncertainty. So we often discuss in the toxic tort context the idea that the standard of proof and the kinds of evidence required can sometimes incentivize corporations not to test their products because that kind of uncertainty can protect them from being held liable for putting dangerous products on the market. If you don't know, you can't prevent it. So a question to be asked is the types of uncertainty in criminal prosecutions, could it be having that type of incentivizing effect? Is it the same thing in this different context? That's just a brief look at uncertainty in law, but it's also important to note this notion of uncertainty in science and the difference that these various standards of proof can raise. So in terms of uncertainty in science, when a scientist says they're not certain, as we know, this can mean I have a 2% doubt, not I'm not sure on a balance of probabilities, et cetera. And so this idea of a difference in the approach between evidence of absence of danger as opposed to absence of evidence with regard to danger. Which of these is the most applicable in criminal prosecutions? So when the benefit of the doubt, so to speak, what the standard of proof is on a balance of, beyond a reasonable doubt, if we have an absence of evidence of danger, an absence of evidence of deleteriousness, then this obviously will act to exculpate the defendant. Does that suggest then to the public, to other defendants, that there's this image that we have some certainty in relation to that? This product was placed into the water, and the court found that it did not cause a deleterious effect. Does that suggest that the product is safe, that we can continue to allow emissions in the water, that we should continue to purchase that product because we don't have to have concerns about the environmental effects? Or does it simply mean that we were not able to prove that this particular defendant should be held liable? So what are the messages as a result of legal decisions based on science? Do they have some impact on perceptions of safety, on future behavior of corporations, and on even scientific research? If we have this idea that, well, there was no liability in that case, so we can presume that this type of product is not causing harm, then we don't need to do any further research on it. We can feel sure that the court said it was okay, that the court said it was safe, because liability was not found in that case. And I think there's also a difference between what lawyers understand and what the general public understands. So if part of the purposes of criminal prosecutions, apart from finding liability on the defendant, may have as part of their role an educational function for the public, many of these environmental prosecutions are widely covered in the media. Does the result that the company was not found liable suggest to consumers, for example, that there is no problem or that there's a great deal of safety? So the science has a significant impact on how law operates, but it's interesting to also note how legal decisions can have an effect on science, on the research agenda, on perceptions among the public in relation to safety, et cetera, with regard to various products. The other thing in terms of uncertainty focuses on whether the question at hand in the environmental prosecution relates to quantitative versus qualitative standards. So if you have a qualitative standard, you must not put X% into this receiving environment, there would tend to be less scientific uncertainty in relation to that. And it's just a question of marshaling the evidence. But where the question relates to is qualitative standards. Is this deleterious? Is this harmful? When it comes to that qualitative assessment, what is the quality of this? Judges obviously have more discretion in terms of interpreting that. And where there's uncertainty in the science, this idea of the qualitative assessment of harm puts more of a burden on the importance of being clear in relation to certainty in science and the confidence of expert opinion, for example. So if we do have situations of uncertainty in relation in particular to qualitative standards, which do arise often in environmental prosecutions, one solution to environmental uncertainty that has been promoted in other contexts is the notion of the precautionary principle, which we're all familiar with. And so this is part of the environmental language that we use in Canada. It's included in several environmental statutes. One of the key elements of the precautionary principle is this notion that if we have uncertainty, we should err on the side of protecting the environment. And in legal terms, sometimes this is suggested to reverse the burden of proof. So in toxic tort litigation, it's much more clear. We should put the burden on the corporation to prove that their substance is safe, that it isn't imposing any harm. It seems difficult to translate that to the environmental prosecution context. It seems more objectionable to say, well, we're not really sure, so we should err on the side of finding liability and wrongly convicting a potentially innocent defendant. It sits much less comfortably with us than in a case of toxic tort litigation. And so the question is, how similar are they? In environmental prosecutions, regulatory offense cases, very seldom is jail time involved. It can happen for repeat offenders, for flagrant intentional violations, but it's extremely rare. So frequently the consequence is a fine or some kind of financial penalty, and indeed reputational harm and other economic harms that can result from that. This seems to be much more akin to a toxic tort litigation than to a murder trial, for example. And so perhaps there is room to argue that the precautionary principle should play more of a role, even in environmental regulatory prosecutions, despite the fact that the standard of care is beyond a reasonable doubt. But they seem to not gel very easily together, and so perhaps additional thinking in that regard is necessary. So scholars such as Barton have suggested that we need new standards of proof in environmental cases. Could we have a standard of proof such as a standard of reasonable ecological concern? Is that, or something new that we haven't invented yet? Do we need to stick to beyond a reasonable doubt? And does it depend on the penalty? Does it depend on the seriousness of the offense? Does it depend on the context? And similarly, should those changes come from the common law and from judges, or should they come from environmental statutes when you have such a serious alteration to these standards? Just the last thing that I wanted to point out before I run out of time is this idea. Many of you may be familiar with this, I'm not sure. And it's a very interesting paper by Charles Weiss that was pointed out to me by Scott Finley of our Institute of the Environment here. And I'll just quickly lead you to it. I hope I will. Apparently I won't. Okay. Well, you'll find it in my paper that's online, and you can also find the link to it. But so Charles Weiss decided that scientists and lawyers can't speak to each other. They don't understand each other's language, which people who've done any multidisciplinary work can attest to. And so he's made an attempt to very concretely line up the standards of proof in law and in science. And then he provides various examples. So what does beyond a reasonable doubt mean? That means very concrete evidence that this has been proven. And so that one is much more similar in science. But when we get lower down the scale, a balance of probabilities, for example, which applies to the defense of due diligence. Where would that line up? Is it 70% in science? Is it 63%? And he ties it in also to the Intergovernmental Panel on Climate Change's definitions of various types of uncertainty. So this type of very concrete tool to assist scientists and advocates to make sure that they can speak to each other and understand each other more clearly when ensuring that this type of science meets this legal standard is extremely useful from a practitioner and a concrete perspective. And so it explicitly addresses what is the standard of proof. It also helps to more clearly enunciate, it helps scientific expert witnesses to more clearly enunciate their level of uncertainty, or conversely their level of certainty, what type of uncertainty is involved, what degree of uncertainty. And it's one tool that we can use to try to help lawyers and scientists to talk to each other more effectively in order to achieve justice in environmental prosecutions.
Thank you very much, Heather. That was great, as usual. We've got some time for some questions. We have started late, but we'll adjust our time accordingly as we go along. So again, just send them forward. I just make an observation that as you're talking about uncertainty, that I think there's actually an intuitive appreciation of the types of uncertainty that goes back a long way, because as you're speaking, I was thinking of that great quote from Mark Twain, who is great on so many subjects, that it's not what you don't know that gets you into trouble, it's what you know for sure that just ain't so. You know, and I thought that's a sort of a nice way of encapsulating some of these issues. I was interested in of course, in much of what you said in terms of the technical aspects here. It did raise a question that came up yesterday in the context of Mr. Justice Gouge's talk, and that is, should we abandon all hope of generalist judges ever being able to get this? Or should we really be thinking more about specialized environmental courts? And of course, there have been, as pointed out yesterday, there have been movements in other jurisdictions in that direction. I don't know if that's something, I suspect it is something that you've thought about, so I'd appreciate comments on that.
Yes, so there's many issues that raised to that question. One is, should we abandon all hope? And so I think it's often pointed out, I think many have pointed out, that judges seem to be more afraid, or they seem to be more trepidatious of the science and the uncertainty in the environmental context for some reason, which I haven't been able to identify yet, because as many such as McLaren have pointed out, in the medical negligence cases, for example, the level of complexity is enormous, and the battle of experts is just the same, but on a daily basis they decide whether heart valve 7432 was the appropriate tool to use, and so they do come to these conclusions. And so I think that, yeah, no, I don't think that it's not possible to overcome these issues, and I think these tools for helping to communicate these issues are important. Secondly, sometimes the environmental uncertainty is not as significant as it's purported to be. This is certainly perhaps more true in product liability or toxic tort cases than in environmental prosecutions. Certainly climate change is the key example where the scientific uncertainty was such an overwhelming hurdle, was more of a cloud, I think, than a concrete issue. With regard to specialist courts, there's so many different tools that we can start to think about. I've read quite a bit of the literature on the project, I think it was in the 70s or 80s, where they were going to propose a science court in the US, and many advantages to that, but again, many disadvantages as well, that things become streamlined, things become separated from general legal principles. But one of the biggest problems in environmental cases is I think that's still working on the notion that, well, we'll come to the right scientific answer, and then we'll just tell the lawyers what it is, and they'll just slot it into the slot. Whereas there's so much uncertainty in science as well, so much subjectivity, sometimes a lack of neutrality. So they're wrestling with it at the same time. So I'm not sure that separating it might be the answer. Another alternative is the I always get it wrong, the Land and Environment Court of New South Wales. And I think they have a combination of lawyers and scientists together, more like a tribunal type approach. I'm attracted to that idea, that separating them doesn't seem like the right thing, but working actively, physically working together might be more helpful.
I wonder if just a follow-up to that. You mentioned that judges are comfortable dealing with things like medical malpractice suits. They get them all the time. I wonder if that reflects an earlier comment you made that there are some disciplines whose inquiry is closer to a legal inquiry, and clinical medicine being one, as opposed to epidemiology, for example.
Yes, that could be the case as well.
Whereas with the environmental inquiry, you are more in an epidemiological sort of paradigm with climate change, for example, over many, many years.
Yes, true.
Yeah,
Yeah, that's true.
A question from the floor. Some organizations with environmental responsibilities, for example, the International Joint Commission, have endorsed a weight of the evidence approach to some environmental risks. Should we expect to see greater reliance on this type of decision-making standard? And I guess that could be in courts or in tribunals like the IJC, which has a quasi-judicial function.
Right,
as well.
absolutely. I think that flexibility and evolution of standards is certainly a possibility, but I think the harder question is it possible in environmental prosecutions? Are they really so different and so much more like criminal cases that wiggling the standard and wiggling the burden of proof, et cetera, is too objectionable? Or is that a misperception of what environmental regulatory offenses are? I think that's the nub. Can we look at that as being part of the overall environmental spectrum, or are they really standalone?
One of the points you brought up, the Weiss scale, and I guess you could have variations on that, but the idea of trying to marry science and scientific and legal concepts of proof and somehow figure out how they translate. That sounded very attractive, and I could imagine it being attractive, especially, for example, even in a jury trial in terms of a charge to the jury. So I guess my question is, have you seen anything in litigation that suggests any judges are willing to move in that direction in the context of prosecutions? And alternatively, perhaps have we seen any movement in that direction in regulatory tribunals, which may sort of be a leading indicator?
Right. I would actually defer to the practitioners on that one.
Okay.
I'd love to hear their opinion on that.
Okay.
Yeah,
Okay.
I don't know.
Okay. I think we will move along smartly since, which you have, and I thank you very much for it. But we did start late, so we'll move along now. And thank you very much, Professor. We're now going to move on to something completely different. And that is a subject that, if anyone's of my vintage, or perhaps somewhat less, was a question of great interest, and that is what role would the public have in terms of enforcing environmental law directly? And certainly when I was in law school, we had all sorts of suggestions that we could be out there using the Fisheries Act like anyone else, and this was just a matter of time. I'm not sure if our hopes have proven out, but it did seem to us when we thought about this subject that it would be useful to talk about that, especially in the context of private prosecutions. Whether or not there is still life in that possibility, and what role it might play. And we're just delighted to have with us two people from Ecojustice, two lawyers from Ecojustice to make that presentation. Albert Cole, who has had a long history in environmental litigation, both as a Crown litigator and now with Ecojustice, and John Swagan, who I really can say needs no introduction, for those of us 30 years, 25 years ago, looking around for environmental texts, John Swaggins was the first one you went to, and for a time it was the only one. So I am delighted to have him with us here today, and I invite both him and Mr. Cole to come forward.
Hi, good morning. My name is Albert Cole. I'm a staff lawyer with EcoJustice. We've divided our presentation into two parts. I'm going to give a very brief introduction and outline. John's then going to take the stage and speak about the history of private prosecutions, the continuing right to bring such prosecutions, examples of private prosecutions that have had an impact, as well as why private prosecutions continue to be important today. I will then speak about some of the hurdles to private prosecutors. So first, I wanted to frame our presentation, our discussion, on two private prosecutions that we recently completed having to do with migratory birds and window strikes. So many of you will have heard about the problem of lights drawing birds into dangerous areas and strikes with windows. In fact, the bigger part of the problem is the fact that windows reflect images of vegetation, trees, and sky that draw birds into violent collisions. Canadians and Canadian laws have long valued migratory birds. Many of you will know of the Migratory Birds Convention Act that itself grew out of the Migratory Birds Treaty between Canada and the U.S. in 1916. Since that time, of course, our Migratory Birds Convention Act, which mainly focuses on protecting migratory birds through protecting of nests, that convention has been updated and amended on a number of occasions up until recently. So we continue, obviously, to value migratory birds for various reasons. The dangers they face today are different from mainly the hunting danger that was the case in early part of 1900s. We value migratory birds because they disperse seeds, because they pollinate plants, and of course because they protect agricultural and other crops from insects. In fact, it's not only these generous services, ecological services provided by migratory birds, but of course we value birds because of their beauty. In fact, because of that beauty, migratory birds, bird watching and birding creates a lot of economic activity. So the story, of course, in our part of the world about migratory birds starts every spring in Central and South America. These birds, many dozens of species, work their way northward, flying at night, where they take advantage of weather conditions and then fly several hundred kilometers or more, and then need to land, of course, to replenish their energy after a long night's flight. They then often will stop, of course, in cities where these are routes they've followed for hundreds of thousands of years. Some of the hazards they face today weren't around 100,000 years ago or even 300 years ago, and these are these glass buildings that we, of course, love and seem to be quite an obvious part of our urban landscape. So even though, so birds, of course, haven't had an opportunity to adapt to these glass structures that lead to their deaths or injuries. So having flown hundreds of kilometers and being sort of close now to our boreal forests, they face this indignity of literally cracking their skulls against the windows of many of these office buildings and other buildings. It has nothing to do with the height of buildings. It's really the reflection of windows that causes the problem. The two cases that we undertook having to do with two Toronto-based developers, Cadillac Fairview and Menkes, were really questions of what is the proper interpretation of the Environmental Protection Act, Section 14. Is the reflected light radiation that causes an adverse effect, namely death and injury to birds? And secondly, under SARA, under the Species at Risk Act, Section 14, are these building owners actually killing birds under the definition of that section? So even though we will see often we get these Environment Canada press releases, and we'll see about a hunter who has accidentally shot a migratory bird when his permit didn't allow that. These deaths of migratory birds in cities from window collisions are both massive in number, they're predictable, and tragically, they're also, or equally tragically, they're also preventable. Despite that, we've seen virtually no action by federal or provincial authorities, and the only action that we have seen, or significant action, is by municipal governments. So with that, I'm going to turn it over to John for the next approximately 15 minutes, and then I will speak about some of the hurdles faced by private prosecutors using our cases as models. Thank you.
Thank you, Albert. Thank you for coming out on this snowy day. Thank you to everybody who's watching this on the internet and avoiding coming out in the snowy day. And thank you to Searle and the University of Ottawa for putting this on and for inviting us. My message today is that private prosecutions are alive and well. Private prosecutions go way, way back historically to before the Norman Conquest. Before the Norman Conquest, the criminal law was very much like our civil law, and it was always the victims or the victims' families who were the prosecutors. And the Law Reform Commission paper on private prosecutions has a good history of private prosecutions, and it states that back in those days, the ultimate result of the adversarial contest was often violence. They don't go on to explain exactly why that was the case, but it was, and one of the values of having private prosecutions where there aren't public prosecutions is that it does provide a safety valve against violence. And that was the original nature of British law, was that it was very much an adversarial system in which the public interest wasn't being vindicated so much as the private interest. Within about 50 years after the Norman Conquest, justices of the peace started to be appointed, but those justices of the peace weren't like what we considered or what we know as a justice of the peace. They helped the victim by collecting evidence and presenting it to the judge. In fact, it wasn't until 1879 that a Department of Public Prosecutions was established in Britain, and even then the public prosecutor was restricted to prosecuting serious criminal offenses where the victims or their families for some reason weren't able or willing to conduct the prosecution. We then got into the period where there was a police force, which is a relatively new innovation. It happened in the 1800s, and the police force took the place of these justices of the peace, and we began to switch to a public prosecutor system. But initially, in the late 1800s, when the Public Prosecution's Office was established, the public prosecutor was limited to exceptional cases, and it still remained largely a system of private prosecution. And in the 20th century, private prosecutions were in fact recognized in British legislation as being a right that continued. So the reason all of this is important for Canada is that Canada adopted British criminal law. When our criminal code was passed, it said that the British common law of crimes continued to be in effect in Canada unless it was taken away by statute, either by the criminal code or by another federal statute. And at least for summary conviction offenses, that right never has been taken away, except for certain specific circumstances. And those circumstances are when a statute specifically provides for the consent of the Attorney General or of another cabinet minister before someone can privately prosecute. And of course, the other situation is at common law and by statute in Canada, the Attorney General has the right to intercede. The Attorney General can step in and either stay a prosecution and refuse to let it continue, or take over the prosecution and continue it. But with those exceptions, the right of private prosecution still does exist in Canada. Some provincial offenses are conducted under the summary conviction provisions of the criminal code. And for those, there is a right of private prosecution that's not taken away by the criminal code. In other cases, the right of private prosecution is subject to provincial offenses legislation passed by the provinces. I know Ontario has such a statute, BC does, and Alberta does. And I believe none of those statutes prohibits private prosecution. In fact, in Ontario, when they passed the Provincial Offences Act in 1979, the Ontario government specifically looked at whether it should curtail private prosecutions and decided not to, on the basis that there were already sufficient safeguards in the system against abuse of private prosecutions, that there was no need to do away with the private prosecution. There has been one change in the criminal code that's noteworthy. In 2005, the criminal code was changed to provide for a mandatory pre-enquête in every private prosecution. There has to be a mini hearing, and Albert's been through. I haven't never been through one of those, but Albert has and can tell you about his experience. And a justice has to be satisfied that there's some basis for the prosecution going forward. But if that barrier is met, then certainly prosecutions can go forward privately in Ontario. That's the criminal code, so anywhere in Canada. I want to talk about some of the early environmental private prosecutions in Ontario and their effects and the value added from them. I was involved in a few of those. The first one I want to mention is Regina and Sault Ste. Marie and Regina and Cherokee disposals. And the reason I mention that is not because the private prosecutor carried it out to completion, but because it was in fact started as a private prosecution and ended up being a landmark decision in Canadian law. It was a prosecution under the Ontario Water Resources Act, which was the primary environmental statute in Ontario for decades until the Environmental Protection Act was passed in 1971. A Mr. Mark Caswell owned property in Sault Ste. Marie, and the Root River and Cannon Creek ran through that property. Next door to his property was a polluting garbage dump. The land was owned by the city of Sault Ste. Marie, and the city of Sault Ste. Marie had a contract with a private disposal company, Cherokee Disposals, to operate the site. The site was pouring pollution onto the neighboring land. The Crown took over the prosecution of Cherokee. Cherokee was quickly and cleanly convicted, end of story. But the prosecution that the Crown carried on was also against the city of Sault Ste. Marie, and that raised the question of what is the proper basis of liability for regulatory offenses. And at the end of the day, the Supreme Court of Canada declared the basis for liability in regulatory offenses, as you know, to be primarily strict liability, sent it back to a new trial, and in fact the city, on the basis of lack of due diligence, was convicted again at the new trial. And it all started as a private prosecution. After the Environmental Protection Act was passed in 1971, the Ministry of the Environment didn't prosecute under it for several years. And most of the earliest prosecutions under the Environmental Protection Act were, in fact, private prosecutions. In most cases, members of the public begged and pleaded with the ministry to take legal action, but they just wouldn't prosecute, and they often wouldn't use the other tools that they had at their disposal, such as pollution control orders and terms and conditions on licenses and approvals and permits. This was the case with the Inco prosecution, for example. A group of students in Sudbury, calling themselves the Sudbury Environmental Law Association, asked the Ministry of the Environment to prosecute Inco for its air pollution. Inco was daily pouring out jet black smoke from its refinery, and the ministry refused to prosecute. These students prosecuted and got a conviction, the first conviction ever under the regulation, under the air pollution regulation under the EPA for excessive black smoke. There were two other charges that were, of which Inco was acquitted, but they did succeed in getting a conviction on that charge. And I know at least one commentator claims that the spate of ministry prosecutions against Inco that followed shortly after that were a result of this prosecution. Whether that's the case or whether there were other factors involved in changing the ministry's approach, I don't know. Another case in which I personally begged and pleaded with the ministry for about 2 years to take legal action and finally launched a private prosecution, and was Tyson versus Hale, or as it might be more properly called, Regina, on the relation of Ian Tyson versus Hale. This was a case for the folk singer Ian Tyson, who contacted CELA. Ian owned a ranch around Newtonville, Ontario, and his next door neighbor was a polluting garbage dump, and leachate was running down the side of the hill, visibly a stream of it running down into the creek on Ian's property. It would seem to be a pretty clear case for the ministry to take some sort of remedial or preventive action, but they didn't do it. We did prosecute. Hale was convicted, and the case had an ironic turn of events in that years later, when the site continued to be a bad polluter, the ministry did try and shut it down, and it went to civil court to get an injunction against the continued operation. And the judge said that he wanted to see evidence of prior convictions before he would give and grant an injunction. And the Hale case that we did was the one conviction that the ministry was able to put before the court. Let me know if I'm running out of time, and I'll be happy to wind up. I'm not sure about how much time I'm taking. Noise was also an area where the Ministry of the Environment was unwilling to act for 5 or 6 years. Initially, well, let me back up. The Section 14 of the Environmental Protection Act says no one may deposit or emit a contaminant likely to cause harm to the use and enjoyment of property. And contaminant is defined to include noise. So the ministry presumably could have prosecuted noise events under that section, but it wouldn't, because at first it was developing a regulation and it claimed that it had to have a regulation in place first. But the regulation just never seemed to come. Later, it abandoned that approach and decided it would turn over enforcement to municipalities and started to develop a model municipal noise bylaw for municipalities to use, and for that reason it wouldn't prosecute. Well, the public continued to suffer, and CELA launched a couple of private prosecutions. One was fairly minor. It was just a noisy air conditioner that was bothering a neighbor. But it did get a conviction and demonstrated that the law could be successfully enforced without the need for a regulation. And for the neighbor, it resulted in the air conditioner being moved to a different location where it didn't bother the neighbor. Kelson Spring Products was the case of a noisy bed spring factory in a residential area. And I was with CELA at the time and got a call about this. I went out to see what was going on myself and met with the neighbor. And when the neighbor told me that the birds in the trees also bothered him because of their excessively loud chirping, I decided that this wasn't something we would pursue, at least for that neighbor. But then a few weeks later, that neighbor came back with the entire neighborhood organized and wanting action. So we did prosecute. That prosecution didn't succeed. We made errors in the way we drafted the information, and the informations were quashed. But the effect that it did have is it resulted in the ministry shortly after that issuing a control order against the factory. The ministry had only issued one other control order for noise in the 5 or 6 years it had been in existence, and that had just been issued a month or two before Kelson Spring Products. So the ministry then stepped in and took carriage of the matter. Ultimately, the combination of the prosecutions, we also laid charges under a municipal noise bylaw, and those charges weren't quashed. Ultimately, the combination of events did cause the factory to close and move to a more appropriate location. And the last private prosecution I want to mention is the Strathy prosecution, and I mention it because it's an example of how a private prosecution can result in a lot of public education about an environmental problem. This was a case where a contractor was doing some construction at Brown Avenue School in Toronto, and in the process damaged a mature maple tree on the boundary of the school's property and the city's property. Shirley Strathy, who was a landscape architecture practitioner, got upset about this, and she came to CELA. And we successfully prosecuted. The result was a front page article in the Toronto Star and the Globe and Mail about the tree that went to court, and worldwide publicity about the case in Reader's Digest. Shirley won an award from the Association of Landscape Architects as a result of her efforts. And years later, decades later, I can now walk the streets of Toronto and I see at every construction site a barrier built around the trees to protect them from construction equipment, not as a result of this case directly, but it's an illustration of how the law in some cases has evolved to give us better protection. Those barriers are built pursuant to a municipal tree protection bylaw that requires such things. So usually private prosecutions follow serious attempts to get government action that are unsuccessful. And they continue to be a minor part of the spectrum, but a necessary part. They fulfill a number of purposes. One is transparency. They shed light on how government is or isn't doing its job. They also fulfill the purpose of providing for government accountability, which obviously is related, and they fulfill the purpose of providing access to justice to ordinary citizens. Access to justice having been recognized by our courts as a charter value, one of the key societal values that underlies the provisions of the charter that explicitly give us protections. The Law Reform Commission of Canada looked at private prosecutions in 1986. It looked at them in the context of the criminal law, but it stated that its findings applied equally to regulatory offenses. And the Law Reform Commission found that private prosecutions should be allowed to continue. And in conclusion, I quote its finding: private prosecutions are not only desirable, but also necessary for the proper functioning of the Canadian prosecution process. This form of citizen/victim participation enhances basic democratic values, while at the same time it promotes the general image of an effective system of administering justice. I look forward to the day when we won't need private prosecutors, but it may be some time from now. Thank you.
I'll briefly speak about some of the hurdles that we face as private prosecutors. And the first one, of course, especially in small organizations, this task of trying to separate the prosecutor from the investigation. Now, Susan made a helpful comment yesterday saying, well, in many cases, that's no longer that realistic in terms of separating that completely, given the complexity of some environmental prosecutions and the need for lawyers to be providing advice, whether for search warrants or other expert evidence and other factors in prosecution. So today we see a bit more blurring of that, perhaps not to the state. If you watch a lot of American TV, you see how the prosecutors will show up at the door of the perp sometimes and be cajoling them into giving damning statements about their crime. But certainly one of the things that we do have to be careful about is ensuring that as prosecutors we don't also become witnesses in the case. So whether in taking of statements or in our case where we had dead birds that we needed to get to the Royal Ontario Museum for identification in terms of threatened species and then to the lab for analysis as to the cause of death. I mean, those are areas where we still want to maintain some separation, as I say. However, in a small organization that can be quite challenging, but still necessary. The second thing, of course, second challenge is the obvious one that we all face as prosecutors, and that's the issue of disclosure. We certainly went into these prosecutions accepting that our duty of disclosure was the same as the Crown's duty of disclosure. In fact, I think we tried to go far beyond what we expected the Crown would voluntarily do, because we didn't want to get into a situation where we'd be in the midst of a trial. Remember, we're a small organization, and then have adjournments or other problems with disclosure. So we we really went quite far, and the judge himself commented favorably in our case about how far we'd gone to try to anticipate defense arguments and provide disclosure. Now, I say the task in our case was daunting because we had, in each case, over 800 dead birds. Now, the group that collects these birds, they not only they take notes, they document them in spreadsheets, they submit the spreadsheets, they often photograph these birds. They're put into larger spreadsheets. So all of these notes and photographs and email conversations, all of these things we had to request from this group called Fatal Light Awareness Program, which routinely collects these birds and disclose it to defense. So it was a little bit on a smaller scale, like doing 800 murder investigations, because we had to disclose all of the information we had about each of these meticulously documented bird deaths. Not that we needed to prove 800 bird deaths, but we certainly wanted to give some context to the court in terms of the number of birds that were killed. And once you go down the road of disclosure, there's of course no limit in terms of what has to be disclosed relating to those deaths. The third issue was one that we sensed or had practical experience in a number of occasions where there seems to be a certain protection of turf or the tasks that public crowns do, and a certain jealousy around private prosecutors perhaps treading on their territory. In one particular case, in the Cadillac Fairview case, we were in the midst of an adjournment request by the defense. Defense had presented its argument, we had replied, and the judge was sitting on the bench reviewing the materials. And at that point, there were several crowns sitting beside me, and one of them, quite a senior one, jumped up and he approached me and he said, "You can't do this. You can't do private prosecution. This is the Crown's job." And I looked over at him. I was a bit surprised by this commentary, and I said to him, "Well, that's very interesting." And he said, "Interesting?" He said, "That's not only interesting. This is contrary to the Martin Committee report, and only Crowns can do prosecutions." So at this point, of course, we'd been through the process, gone to the Justice of the Peace, we'd given notice to the Crown, we'd gone through the pre-enquête, we'd gone through pre-trials. In fact, we'd met with the regional senior judge about joining the two informations we had under provincial law and federal law. And just before leaving the court, I bent over to the other Crown that was sitting there, and I said, "What's that fellow's name?" And she said, "I agree with him. You can't do this." And of course, I did go back after this and review the Martin Committee, and there is some reference in the Martin Committee on page 188 in the context of disclosure, talking about private prosecutions, but it does say it's desirable in criminal context, and we certainly understand this, for the Crown to be taking over private prosecution, these sort of common cases where a neighbor will charge the other neighbor with assault and there'd be a countercharge. We certainly see the value in prosecutors taking over those cases. But my comment would be that, of course, as opposed to fearing our involvement of private prosecutors, it really should be something, given the rarity of these cases, should be welcomed. Remember our organization, EcoJustice, we have 15 environmental lawyers across the country. We've been involved in some of the drafting of some of these environmental laws, and certainly always comment on any changes to the laws. So we certainly have expertise in environmental laws. And in terms of procedure, certainly some of us in the organization have been involved, whether as Crown prosecutors or otherwise, in prosecutions. And finally, obvious issue is that of costs, the cost of a private prosecution, not only the investigation and time of lawyers, but of course experts and analysis. We were very fortunate in our case to have all of our experts testified for free and gave us their reports for free, which was a great benefit. And certainly during cross-examination, in some cases, quite a surprise to the defense lawyer who assumed that we had paid large amounts for these expert reports. The other case, in terms of cost, of course, it's certainly a great burden, but the advantage, I would call it an advantage, of private prosecutions as opposed to civil litigation, which is much of our practice at EcoJustice, we need not fear, nor does the public prosecutor need to fear, the awarding of costs against the prosecutor in terms of an acquittal. So the fact that we can't recover costs except under the Fisheries Act, the fine splitting arrangement. The fact that we can't recover costs is in general an advantage, given that we can't have costs imposed against us, so that wouldn't deter a private prosecution as it might civil litigation. So finally, in terms of the outcomes of our cases, the case against Cadillac Fairview was related to an office structure in North Toronto. It's essentially a mirror building that sits beside a ravine. They've had bird strikes there and deaths for almost, well, since they've put up the structures in the 80s. And this group, Fatal Light Awareness Program, has been collecting dead and injured birds there for many years, more recently collecting threatened species. So in this particular prosecution, we had a number of birds of 2 species that were killed in window strikes. So we lay charges under Section 32 of the Species at Risk Act and Section 14 of the Environmental Protection Act. What was key to us, of course, was the legal ruling, so legal interpretation. The court concluded, this is Judge Green of the Ontario Court of Justice, he concluded that number 1, the Species at Risk Act did encompass bird deaths or injuries from striking building windows, specifically rejected Cadillac Fairview's argument, which is we're just building owners. It's unfortunate that the birds run into our windows, but you know that's the law doesn't contemplate a conviction on that basis. The court rejected that, said specifically Species at Risk Act. The conduct has to be unintentional. We, of course, always framed our cases. You're not just a building owner. You're using a particular window product, which is these mirror windows that are leading to these tragic outcomes. The court agreed with us on Section 32 of the Species at Risk Act. I don't think there are any previous cases on this. And of course, Defense Counsel had, in their opening statements, really sort of highlighted the fact that there was no such case anywhere in Canada or no such case in North America of companies being prosecuted for bird deaths from window strikes. Under Section, this is perhaps too technical, but under Section 14 of the Environmental Protection Act, the court found that indeed the discharge of radiation or reflected light was an adverse effect that was causing bird deaths. So agreed with us on that interpretation and found beyond a reasonable doubt, and this was certainly something that took a lot of time at trial, agreed or sort of found that beyond a reasonable doubt we had proven that these birds died from window strikes, that it was because of the reflective nature of the windows, and therefore found that the prosecution had proven beyond a reasonable doubt the actus reus, or the prohibited conduct. Somewhat surprisingly to us, the judge then found that Cadillac Fairview had actually acted reasonably in terms of trying to deal with the problem. We don't need to get into that except perhaps in questions, but as I say, it was a legal ruling that now applies across Canada in terms of the Species at Risk Act and across Ontario in terms of the Environmental Protection Act. Very helpfully, Judge Green, in commenting on the previous case that we had done, which was also an acquittal by a Justice of the Peace on the EPA charge, the Judge Green said, and this will help us in the appeal, he said the Justice of the Peace gave a very concise, which he said diplomatically, very concise, it was a very brief oral ruling, after an 11-month adjournment, said the Justice of the Peace was unencumbered by reference to the legal jurisprudence. So that will hopefully help us on the appeal in that particular case. So finally, in terms of what John has talked about and what we've certainly found in this case, private prosecutions are valuable in terms of motivating action by polluters. During the case itself, and it's quite stressful, we often don't realize that as prosecutors for witnesses. When our witnesses got quite stressed, I'd often say to them, well, can you name the 2 commercial buildings in all of Canada that have had their windows retrofit? And of course, the answer to that trivia question was the 2 companies that we had prosecuted, because after the charges were laid, and even though they had said in the pretrials that these are frivolous charges and unprecedented and ridiculous, each of these companies then started investigating seriously window products. And it's a simple concept. It's simple. window films with markings, visual markings on windows that they've now installed in both of these buildings. It could be lines or dots or anything, but spaced visual markers so buildings, birds know they're flying into windows rather than into trees or vegetation. So motivating action by polluters, that was a case in point here in our two cases. Number two, influencing and educating the public. Certainly there was a fair bit of attention to these cases. A bit of education also about tenants, about the fact that there are solutions now to these issues. Cadillac Fairview, throughout these number of years that they knew about the problem, tried to convince its tenants, or only told its tenants that it was a lighting problem, turn your lights out at night. It was actually a daytime problem, which is how most of the collisions occur, which are during the day because of these fatal illusions. So tenants are now more empowered because of the knowledge and because of these products that are now on the market. And finally, private prosecutions, as John mentioned, can inspire, sometimes force government action. These rulings on Section 14 of the EPA mean that the Ministry of Environment or building owners who are killing birds from reflective windows must obtain an environmental compliance approval. And hopefully the ministry will take action where companies are not taking that action. Also, Canadian Wildlife Service, so I can't say in this case we've inspired or forced government action in terms of the federal government, except they still go after hunters that kill individual birds. These are, widespread, massive problems that need attention by the Canadian Wildlife Service. We know the problems the Canadian Wildlife Service faces in terms of resources, but that's simply another reason, as John mentioned, not to fear private prosecutions, but to see them as a useful tool in those rare occasions where government either is unwilling or unable to take action. So I'll conclude there, and then we'll look forward to your questions.
I think we're going to take a few minutes for questions. We'll just be very short at the end of the day with our closing remarks. One of the things I was just fascinated by in this was the history of private prosecutions, especially pre-Norman conquest. You don't often discuss that in environmental law. I'm wondering, given the common history of that in the common law, how other jurisdictions have handled private prosecutions. Have they been more or less aggressive? Has Canada got something to learn from those jurisdictions, or are we relatively advanced?
The U.S. has citizens.
You'll need the mic.
I know Germany and France have inquisitorial systems rather than adversarial systems, and the state therefore takes a very active role in prosecution, more active than here once you get into court. I don't know how that affects private prosecutions. In the U.S., there are citizen suits, and I don't know, you may know more about the citizen suits than I do, but they are suits, I believe, that are available to citizens civilly to enforce environmental laws. And I believe there are no costs awarded against the citizens groups if they lose, which is a major concern. Do you know more about them?
I don't have any other comment on suits in the U.S., but certainly in the U.K., this private prosecution still exists. Now, I understand they've, fettered in some way the rights of private prosecutors, but still exist in the U.K. And I should note, in terms of the prosecutors, public prosecutors' control over these private prosecutions, that here in Canada, that right still obviously exists in all of these cases for the public prosecutor to, number one, attend the pre-enquête in case of federal charges, but then number two, to intervene either to take over the private prosecution, which certainly citizen groups would often welcome, or unfortunately, as they often do, intervene to stay the charges, which, if it's a competently prepared investigation or something that requires a bit more work, but that is, merits attention by way of prosecution, we certainly would encourage governments not simply to have a policy of intervening and withdrawing, as they do in some jurisdictions in Canada, such as British Columbia.
Now, there's sort of a related question here that's come up from the floor. Sometimes legislation provides for the fine or a portion of the fine penalty to be awarded to a private prosecution or a complainant. I assume the reference is to the Fisheries Act regulation. I don't know if there are others. Does this happen often? Is this a meaningful incentive? Should it be made common? And maybe I could just add my own little footnote to that. In the United States, private prosecutions in antitrust, of course, are very lucrative, and they're a major driver of antitrust policy there. I'm not too sure if there are other examples in Canada in terms of environmental legislation or not, but I'd appreciate your views on the potential here.
Yeah, we looked, and apparently the Migratory Birds Convention Act used to have a fine splitting provision, but the only one we know of in Canada is the Fisheries Act. And to give you one case example of that, our organization did a prosecution a number of years ago where, under the Fisheries Act against the city of Hamilton, the city pleaded guilty, and half of that fine then went to the private prosecutor, which was used to set up a group called Environment Hamilton. Right. So there was an example of the fine splitting actually, benefiting the prosecutor. In another case that we did against the city of Kingston, there were arguments being raised by defense that weren't pursued, that this fine splitting constituted a type of bounty, and as they called it, and that would infringe rules around champerty and maintenance. That wasn't ultimately decided, but that might be our fear, that if you have more statutes that incorporate that sort of thing, we might also see more challenges. Would it be helpful? Well, certainly getting part of the fine would be helpful in those cases, but often, as I say, our motivation isn't necessarily getting the fine other than for its deterrent value. My only fear would be that if it's incorporated into more statutes, we might see more challenges to that, and perhaps even provoke other challenges to private prosecutions in general that we've already seen.
Okay. A question on a specific case that you referred to in terms of your free experts. Was the impartiality of the experts questioned because they provided their services for free? I could see that being an issue of some concern for people.
Well, in both cases, our expert was a former Dean of Arts and Science and supervisor of the physics department at the University of Toronto. And he hadn't previously testified in court. There was actually an interesting exchange where defense was cross-examining this expert and said, well, what's your connection with Ecojustice? And he said, I don't have any connection with them. He said, well, what's your connection with Ontario Nature, who was the informant in the first case? And he said, don't have any connection to them. I said, well, how much are you getting paid? Well, he said, I'm not getting paid anything. And he said, well, why are you doing this? And he said, well, I'm doing it as a public service. And kind of a nice answer from an expert in that case, and weighed against the defense expert who had testified. He had said he had testified in hundreds of cases and on a pretty humble resume. So we were quite, certainly in the second case, the judge accepted the expert evidence of Dr. Sinervo, who is a physics professor, on this science issue of, is it an emission, is visible light radiation, those science issues. So that, I think, and the defense didn't even call an expert on that. So there wasn't an issue in terms of the expert's qualifications, or in fact, ultimately the judge accepted his evidence. And I'm not sure if I answered the question.
I think so.
Okay.
Another question that's both specific and more general, is Cadillac Fairview appealing, and could you comment on what the process might be if Cadillac Fairview appeals the decision? Would the Ecojustice continue carriage of the file, or could the government of the Crown take over?
Well, even though we were disappointed by Judge Green's finding on due diligence, it was a very tidy result, in that, of course, the legal rulings went in our favor in terms of the interpretation of the section. The defendants were ultimately acquitted, but we don't think you could even appeal an acquittal, or nor would they be motivated necessarily to appeal an acquittal just because they were acquitted. They might not like the legal rulings, but those now stand. And certainly, it's the first ruling we're aware of under Section 32 of the Species at Risk Act. The EPA ruling, I suppose, arguably Judge Green's decision is at the same level of court as the Justice of the Peace. However, given the nature of the Justice of the Peace ruling, we think we'll be successful in that particular appeal, which we are appealing, and we'll get a date shortly. The Cadillac Fairview case was appealed by neither side.
A more general question here. In British Columbia, and I suspect not just in British Columbia, elsewhere as well, a major threat to wildlife is the railway. Are you aware of any legal actions to deal with that particular problem? And I think it is actually one that runs across Canada, as the railway does.
We'll be looking into that.
Oh, okay. Should the occurrence of private prosecutions for environmental offenses be seen as a failing on the part of the public prosecution system?
Go ahead, John.
Definitely. I guess not in every case. There will be cases where the government has good policy reasons for not prosecuting. They may want to take other enforcement action, or they may even be justified once in a while in taking no action. And there will be private prosecutions that are not well-founded, where the motives aren't good or the evidence isn't good. But in many cases where there is strong evidence of a serious problem, and a sometimes inexplicable reason for the government not to take action, or where the government resources are just spread too thin, then there can be very good reason for prosecution in those cases.
This actually is a related question. You may want to expand on it. You may felt that this, you've already answered it. Can you comment on the role of the Attorney General relating to private prosecutions, and what factors would lead the Attorney General to take over the prosecution? I don't know if you have anything else to add to that.
Well, we think the Attorney General should answer that question.
Yes.
I mean, we would, of course, like it to be based on policy, as opposed to, I mean, not sort of a blanket no, or, well, it could be a blanket yes, but something based on a reasoned approach. I mean, do the charges have merit? Does the investigation reveal an infraction? In terms of whether it should be the Attorney General or a private prosecutor prosecuting the case, well, look at the competence of the private prosecutor. I mean, we would certainly say John and I have significant experience both at the government level and doing private prosecutions. That's a factor we would hope the Attorney General would look at, as opposed to having a blanket policy saying either, yes, we will intervene to stay the charge, or yes, we will intervene to take it over. A reasoned approach would certainly be welcome across Canada.
I wonder, just finally, if you could comment on what is sort of a middle step short of private prosecutions, and that is a statutory right in a number of statutes to request investigations. I think SEPA has it, SARA has, I think, a provision like that. Is that something that environmental NGOs find useful, or is it something that EcoJustice, for example, uses to establish a record? Or?
Well, I'll say clearly, I mean, that process has been very frustrating, and it's certainly something we look at as an option. But in a private prosecution, then, when you've done some of the work, we're happy to turn it over to government if we think it's going to be a seriously reviewed, and there'd be a serious investigation, serious decision on whether to proceed. Our experience, both personal experience and talking, for instance, with the Environmental Commissioner's Office in Ontario, same sort of right under the Environmental Bill of Rights. A very unsatisfactory response in those cases where, and I can tell you a specific anecdote, where the government said they were going to investigate, what they called investigate. I was called into a meeting, where there were 10 government officials sitting there, and I looked around carefully because I knew a lot of the Ministry of Environment officials, and I said to myself, there isn't a single investigator here. So this is an investigation, and you have a lot of civil servants who aren't investigators, and they're making a decision about whether to proceed. And this was called an investigation. So I would say the general experience is a very frustrating experience. And when you're dealing with a private prosecution where you've gathered the evidence, if the timelines are generally not respected by the government in terms of these so-called investigations or decisions, which means our time is running on limitations period, our evidence might become stale, and at the end of the day, we're very unlikely, based on our experience, super unlikely to get a positive response by government. So we would certainly encourage government officials to take that, these requests for investigation seriously because of the work that goes into them and the opportunities, and not simply dismiss them as apparent, as appears to be the practice, unfortunately, in many of the cases that we're either directly aware of or have heard about from others.
I might just add that we very much encourage governments to pass such provisions. It's very good to have these provisions in the statutes, and we'd like to see more of them. It's just unfortunate the way they're being applied.
Right. Well, I think we will break there, and we'll resume at, I think, around 10 past 11. But I do want to thank very much both our speakers. Just fascinating presentation, and certainly for someone who remembers private prosecutions as a law student, glad to see there's still life in the old girl yet. So thank you. Great presentation.
Thanks for those questions. You hit all the